Okay, I have 1:30. Let's go ahead and begin. Again, welcome to the Justice of the Peace Court, Precinct number 5. I'm Judge DeLeon. We're here today for a contest to a writ of reentry. The facts of this case, that this was a bench exchange originally from Precinct number 6, in which I heard the matter on the 12th, in which this court granted temporary relief to plaintiff, I believe Mrs. Moore, who is not here today. So the defense has elected their right to contest this matter. I have read your brief and the cases that you've submitted, and I'm ready now for your argument, sir.
Thank you. And Your Honor, we do really appreciate, I see Ms. Moore joining. I'll give her a second here.
Well, oh, okay. Mrs. Moore, I can see you now. Can you see and hear me? All right, I'm going to ask you to unmute. Okay, very good. I can see you now. I can hear you now. I swore in Mr. Teeter's client. Let me go ahead and get you to swear in. Please raise your right hand. Do you solemnly swear the testimony you're about to give in this matter will be the whole truth, nothing but truth, so help you God?
Yes, sir.
Okay, very good. We just did the introductions. I brought everyone up to speed on why we're here today, and counsel was about to begin with his argument. Sir, you may begin.
Thank you, Your Honor. And as I was saying, I just wanted to start by thanking the court for giving us a little more time to take another look at this issue. I think the one issue that we really have to answer today is whether Ms. Moore meets the definition of a tenant that's supplied by Chapter 92 of the Property Code. Because if she does not, then the Property Code expressly provides that Chapter 92 doesn't apply, in which case the writ of reentry proceeding would also not apply and her application would have to be denied. So the Property Code defines, as I'm sure the court is very well aware, defines a tenant as someone who is authorized by a lease to occupy a dwelling to the exclusion of others. So there's really two things we're looking for. One, the existence of a lease, and two, a lease that grants exclusive possession to the plaintiff. It's our contention, of course, Your Honor, that neither of those exist in this case, which is our basis for asking that the court deny the plaintiff's writ of reentry application. Ms. Moore has never alleged, to my knowledge, and has certainly not shown, and it is our position that there is not a lease between the hotel and Ms. Moore, and there has never been a lease between the hotel and Ms. Moore. Also, there has not been a lease that granted the right of exclusive possession to Ms. Moore. And that, Your Honor, I think is characteristic and the key defining characteristic and distinction between a hotel and an apartment. With the hotel, with respect to Ms. Moore, just like with any other guests, the hotel never grants a right of exclusive possession or a right to the realty itself, and always maintains for itself the ability to access the room and control the room. Specifically, they can enter the room at any point in time. They have keys for it, and they can enter the room. Of course, that's not to say that they wouldn't honor somebody's request not to come in if they're there, as I'm sure you've been at a hotel before and knocked on the door for housekeeping. You can ask that they come back later, or you can decline it, and the hotels will honor that. They are, after all, in the service industry. But it doesn't deprive them of their ability to enter the room. Similarly, they could, for example, if they needed to for maintenance reasons or for booking reasons or whatever it may be, they could always transfer Ms. Moore or any other guest to another room in the hotel. Again, there's no lease for her occupation of these particular rooms. She's just renting those and she's using those rooms in exchange for payment, if you will. That's the arrangement between her and the hotel, like it is with all guests. So I think the absence of a lease by itself is outcome determinative. But moreover, because the hotel has and has always maintained its right of access, its right of control, and its right of use over these subject hotel rooms, and those rights have never been granted to Ms. Moore, then I think as a matter of law, Ms. Moore does not meet the definition of a tenant in Chapter 92, and therefore Chapter 92 doesn't apply. The court indicated at the outset of the hearing that it has read the cases that we supplied, of course, which we do greatly appreciate. And as I'm sure the court found, there has been numerous cases in the last 80 or so years in Texas that have kind of addressed the issue of a landlord and a tenant versus that of a hotel and a guest. Specifically one that is probably about as close factually as you could ever find in a case, being the opinion issued a couple of years ago by the 14th District Court of Appeals in Houston, that being the Ollie opinion. Very similarly, the Ollies had occupied an extended stay America hotel room for over a year. While they had reservations and they paid discounted rates, they never had a lease and they never had exclusive possession of the premises, because the simple length of time at a hotel does not establish a right or a transfer, rather, of exclusive possession. The Court of Appeals in Houston, very similarly to the way that numerous courts have ruled on this issue consistently over the many previous decades, is that a hotel guest, by virtue of it being a hotel, is simply a licensee with a right to use the premises, but there is no transfer of the right of exclusive possession like you would have with an apartment or something else. That being the fundamental key distinction between an apartment and a hotel is what I think differentiates this case from a typical landlord-tenant situation, Your Honor. So to summarize, I think the cases are very clear that the relationship here is a hotel guest and a licensee and not that of a landlord and a tenant. But even looking just specifically at the definition of a tenant, there is no lease here. And in particular, there is no lease that grants to Ms. Moore the right of exclusive possession. And for those reasons, we believe she doesn't meet the definition of a tenant. And instead, like in the Ollie case and the others, she's properly classified as a licensee. And as the Malum opinion stated from El Paso, lodgers cannot maintain actions for possession of property. So I think once the court properly concludes that there's no lease granting exclusive possession, at that point it follows that they're not a tenant and they cannot maintain the action. So because of those reasons, Your Honor, we're asking that the court deny the applications for writ of reentry.
Very good. Thank you. Mrs. Moore, I'm ready to accept your arguments now.
Okay, Texas law does say normally relationship of hotel guests are considered innkeeper guest relationships. Ollie versus the HWM in 2014, there was a formal eviction that took place. Their situation does differ a little bit from my case. As the TRX's Rio Grande legal aid stated, Texas law takes other factors into consideration in determining what type of relationship applies in these situations. Some of the things that they consider: how long has the occupant stayed there? How often does the occupant pay their stay there? Does the occupant receive mail at the address? And does the occupant have exclusive control? I think this was established at the last hearing in regards to the mail, in regards to me residing over a year. In regards to the frequency of pay, was not like a nightly pay, but was more on the tenant side of a bi-weekly, even weekly pay. And then, of course, the mail I stated that I have been able to get there and use their address using my specific room numbers, established that residency over 7 months ago. There were all questions. These are all questions that were established our relationship in 2001, which is outside of an innkeeper guest relationship. The law allows you, Your Honor, to evaluate each case by case by case. Your Honor, I'm confident you will see that our relationship changed from innkeeper guest licensee to a tenant after 7 months of continuous payments for both rooms. When I took exclusive control, meaning I was normally regularly the only person that entered in and out of the rooms besides my 2 children. There were no cleaning services, as well as the mail that I continued to get there for almost over a year. I'm just asking, when you look at the cases that he's presenting, none of these cases are similar in regards to my specific situation. I'm just asking to be able to hear this case with a peer of my jurors, of my peers, and we were headed for that. And the plaintiff withdrew his complaint and then tried to proceed with saying I was trespassing after he withdrew that complaint less than 24 hours later.
Okay, thank you. Counsel, do you have a response to any of that?
Just very briefly, Your Honor, I think that the case is not distinguishable from the Ollie's. As I mentioned, it is a extended stay America hotel. Length of stay is virtually identical, roughly a year. The court opinion in Ollie did not address specifically the mail component, but I'm not aware of a case law that says that if you receive mail that you can, that somehow grants to you the right of exclusive possession. To me, that is an intentional granting by the hotel, which has never occurred here. Ms. Moore does not dispute that she doesn't have a lease. Her only argument in favor of exclusive possession is that she hasn't allowed housekeeping. But again, the fact that she hasn't allowed it doesn't transfer exclusive possession to her. The hotel still has the right and ability to enter the room. Whether they exercise it, whether they need to exercise it is not germane. It's simply whether do they maintain that right, which they certainly do. I think Chapter 92 is clear as far as what's required. That right of exclusive possession has to be granted by a lease. So because there is no lease here and there has been no granting of exclusive possession by the hotel, I think it's the court's only decision here is that the guest is still that of a guest of a hotel and has not become a tenant by virtue of a lease.
Okay. Counsel, I have a couple of questions. One, you all initially thought, you and your client, or I don't know if you were representing them at the time, treated the respondent, the plaintiff in this case, under Chapter 92 because you filed for forcible entry and detainer. That was initially what extended stay did. Is that correct?
Partially, Your Honor. So initially, what happened is Ms. Moore was locked out of the room, I believe, at the beginning of November due to non-payment. Ms. Moore obtained a writ of reentry from Precinct 6 for one of the rooms. At that time, the hotel was managed by a different management company who I also represented. The decision was made at that time that given the ruling on that ex parte writ of reentry, rather than challenge that, to file an alternative pleading which pleads that they are not a tenant, but also for belts and suspenders, so that the conclusion is very clear either way. She was also given the 3-day notice to pay or quit. She did not pay during that time period. So rather than locking the guest out again, the decision was made that we would file a forcible detainer action, which we did. During those proceedings, we maintained throughout that we believed that she was not a tenant. That's in the pleadings itself. But said in the alternative, even if she is a tenant, that we believe we provided the proper notice so that either way, whether there's a finding she's a tenant, not a tenant, we would be covered either way. In that proceeding, we filed a motion for summary judgment on this issue. This was granted by the court, and during those proceedings, Judge Charbonnet mentioned several times that it was his belief, given the case law and the status between the parties, that she was not a tenant and that we did not need to be in this proceeding and that we could lock her out and treat her as a criminal trespasser. At that point, we already had our motion for summary judgment granted, Your Honor, and a writ of possession was about to be issued. Ms. Moore then filed a motion to recuse, which the court granted. But based on the court's statements that she was not a tenant and the findings that they were not a tenant, which we do believe are consistent with case law, the client at that point in time had now changed to a new management company, same owner, but regardless, they made the decision that based on the law and based on what we were looking at as far as a time frame to start over and continue down the road when we already had a firm ruling from the court that this individual was not a tenant, they made the decision at that point in time to dismiss the action and just pursue their rights to lock her out, or to lock her out and then, ask for assistance from officers if she did not show. What transpired after that is we gave her a notice asking her to vacate by 4 p.m. She then filed this writ of reentry application. However, she was still in the room at that time, had not been locked out. When the constable arrived, he found that she was in the room and found that there was nothing to do and said that the hotel had complied since she was still in the room. but even commented to both the hotel and to Miss Moore that she's not a tenant, that she is a licensee because this is a hotel, and that the hotel had its rights to lock her out. Obviously, we didn't do that because we had this proceeding going on.
So what actually happened was contrary to what the court was told at the initial hearing, where that she was prevented from entering the establishment to provide care for her minor and special needs child. That's my recollection.
I believe that's my recollection as well. As the court recalls, there are two rooms at issue. Her two children, I believe an 18-year-old and an 8-year-old and an 18-year-old, if I recall correctly, are in one room. Miss Moore is in another room. At that point in time, nobody had been removed from either rooms and denied access into them, though.
Understood. Mrs. Moore, do you wish to add something?
Yes. So remember at the hearing, I had stated to you, the key to get to my room is the only way that I have access. I can leave a latch. The second that door locks, I cannot gain access to my room. I reached out to the courts the second that the manager refused to update my key. The second that my kids leave the room or one of my children leave the room, they will be locked out. The keys were deactivated, and I stated that several times during the hearing. So my request was, as on the last writ, the constable was required for them to update the keys, which would be no different than them giving someone a key to allow entry into their residence. I can't get in without that key being updated. So that's why I went to because exactly what he just stated is what they were going to do. They were going to have me arrested. After they withdrew it, they were looking at having me arrested the next day, saying that I was a trespasser. And the second I asked her to update my key, because she had sent me that letter, she denied that. She even denied it in constable. So for the constable to state that they were compliant, they were not. I videotaped her. I asked the manager, can you please update my key so I can get in the room? There could be an individual waiting in my room just so I can get back in. But the second we leave, Your Honor, I lost access. Writing that note, with them already having police on hand ready to arrest me, I had to go to the courts and ask them for re-entry so that I would have regained entry with the key into my room and into the building, as you know, gets locked at night.
Okay.
To be clear, Your Honor, after the writ of re-entry was issued, the hotel did ensure that her keys were functioning, and to my knowledge have functioned since that time and function currently.
Okay. Counsel, I have another question. As you alluded to some of the case law, very limited case law in this matter, but when there's, in the absence of sufficient case law, you look to other areas. One of those is the tax code. How would the Texas tax code define Mrs. Moore?
So this was also addressed in the Ollie opinion, Your Honor, because that issue was raised there as well as evidence that he had become a permanent resident. As the court clarified in the Ollie opinion, the tax code neither establishes a right of exclusive possession nor speaks to the relationship between a hotel and guest for purposes outside of just taxes themselves. What the tax code says is that after 30 days, you no longer have to pay certain taxes for your rental of the hotel room. But as the 14th District Court of Appeals clarified, that doesn't transfer the rights of possession. What we're really looking for here is whether there's been a knowing and intentional transfer from the hotel to Ms. Moore or to any hotel guest via a lease, the rights of exclusive possession, and neither one of those exist here.
Okay. Mrs. Moore, do you want to add anything to that question I asked of counsel?
Again, the law allows you, Your Honor, to make that decision in regards to this writ of reentry, and I leave that in your hands.
Very good. Mrs. Moore, I've got some questions for you. I think you mentioned it the last time, but I'll ask again. You consider this residence as your permanent residence, is that correct?
Yes, sir. It's the only residence I've known for over a year.
Okay. And I can't recall if I asked at the last hearing or not. Your Texas driver's license, what do you have registered on it? What is it listed as? The address?
I have a P.O. box listed as my address because, they're not, since the pandemic, that's actually when I became residents here. Since the pandemic, you can't really update anything unless it's expired. So I have a P.O. box that is my address on my driver's license.
Okay. What about, do you have a vehicle?
No.
Okay. What about to vote? Are you registered to vote? And which, if you are, which address is listed on that voter registration?
Do I have a voter's registration? I have one that I'm going to be updating. But I don't have one that I've had sent back. No, sir.
So you are registered to vote?
I am registered to vote.
But the address on the voter registration
is
does
my
not
P.O. box.
reflect it. Okay, it's the P.O. It's not the address at now.
No, sir.
Okay. Counsel, you have anything to respond to the line of questioning that I had for Mrs. Moore?
No, Your Honor, I don't think she's taken any steps, or I should say yes, since I am responding, but just briefly, I don't think she's taken any steps, as she just said, to update any government IDs to list the hotel as her permanent address. I don't know that she has any intention of staying at the hotel permanently. But I think more importantly, I'm not sure that even if she had taken those steps and started identifying the hotel as her permanent residence, that in and of itself indicates there's a lease or a transfer of exclusive possession. So they don't exist, but even if they did, I don't know that they would be factors for the court to consider in determining whether she meets the definition of a tenant.
I understand. I want you to know the perspective that I'm looking at this. If permanent residency has been established, obviously, any landlord would have the right to evict someone. My concern is just to make sure that those fundamental due process protections were afforded, and that's what I look at. But however, in this case here today, one of the things that I did want to ask is what other documents of the public record would clearly establish permanent residency? And the court is not convinced that that's been fully established. So therefore, it's the opinion of this court that the writ of reentry will be denied and that defense may recover possession of both rooms.
Okay.
Any questions from either side?
Your Honor, I've got a couple of questions. I think it's probably disposed of, but to the extent that Ms. Moore were to appeal this decision to the county court, as we noted in our answer, there are some minor party defects for the hotel's owner, as well as the trade name that was used as one of the defendants. But separately, one of the defendants named was Extended Stay America, or excuse me, ESA Management LLC. They have filed a verified denial in this case. I don't know if the court can rule on that now or if there's any need to, but to the extent we can we get an order dismissing ESA from the case entirely because it has no relationship whatsoever to this hotel and is not since 2020?
By all means, if you want to submit an order to that effect, I'll be happy to sign that. And then I believe my colleagues at Precinct 6 will prepare whatever paperwork to ensure that the writ, while temporarily granted, has now been fundamentally denied and that your client can take possession of both rooms.
Okay. Your Honor, I'm to be completely transparent, while I'm pretty familiar with the forcible detainer process, I am not as familiar with the court's process for, in this situation, when a writ of reentry was initially granted, but now has been formally denied. As far as procedures, I'm assuming we need to wait, of course, for the court's order to issue. And is it a writ of possession that will issue, and what's the timing on that?
Counsel, you're very spot on, because I don't believe that there's any set procedure in place. What I would like to do is follow the same procedures as a writ of possession, and that once the order is prepared, delivered by the constable with the red tag placed on the door, giving Mrs. Moore the final 24 hours to vacate, to gather her effects, etc. And then you all may enter that room at the appropriate hour as someone checked out, which I believe in most cases is 11 or 12 o'clock. And then anything beyond that, as my colleague from the other court indicated, it becomes a criminal matter, as with all eviction cases, a criminal matter and no longer a civil matter. Any additional questions?
So I don't have a right to appeal like them, sir?
I'm sorry?
I don't have the right to appeal like he had the right to appeal?
Well, you do, and I need to check the rule book, but I believe there is a time period for that. You're going to have to give the court at least some leeway here to double check that and provide you with that information. Why don't we'll terminate the call here today, and then I'll have my clerk make contact with Mrs. Moore to provide that information, and obviously counsel as well. And that way we know when the writ of or the red tag can be posted and actually Mrs. Moore vacate the property unless there is an appeal filed, in which case it'll go up to county court of law and Judge Pearson will hear that case. Okay, any other questions or concerns?
None from the defendants, Your Honor. Thank you.
Okay.
No, thank you, sir.
Thank you. Good luck.